This is our last screenshot video, there may be two of them, for the crimes course in weeks 13 to 14. Don't worry about the posting number or installment. That was material I had put up earlier last year and then in the fall. What's important is we're going to be looking at the defense in infancy, which really translates in New York to the age of criminal responsibility. And then we're going to shift our gears to the last topic, which is a basic outline of criminal procedure in the state of New York. We did some procedure at the very beginning of the course when we talked about court levels and what cases they handle, etc. Turning to this material I now have on the screen, Defense of Infancy. That's how it's set forth in the penal law under that title, but it really addresses the age of criminal responsibility in New York. As they say back in the day, I know when I first started doing this stuff, the rule was simple. If an individual was 16 years of age or older, they could be held criminally responsible for their conduct. If the person was under the age of 16, that person could not be held criminally responsible for their conduct. Then in the late 1970s, I can't give you the date right now, the legislature in New York lowered the age of criminal responsibility to 13, 14, and 15-year-old individuals. The idea behind it was that for certain felony offenses, the juvenile justice system, so-called, operating out of family court wasn't a sufficient protection for the safety of society. I'm not saying I bought into that, but that certainly was the stated rationale. And it was always optional with the prosecutor. The way it worked is if a 13, 14, or 15-year-old kid engaged in certain violent felony offenses, for 13-year-olds it was limited to homicides, and then for the 14 and 15-year-olds for other violent felonies, the district attorney had the discretion to prosecute the person in adult criminal court or refer their matters to family court, where they could be treated as juvenile delinquents. And then in a rather interesting twist to me, from the late 1970s until the 2018, there was a change in thinking, and there was a concern that maybe in certain instances the age of criminal responsibility should not be kept as it was, but raised, which is really a change then from what the traditional rule of 16 was. So in 2018, the New York State Legislature raised the age of criminal responsibility in New York effective October 1, 2019, to 18 years of age. In the legislature then was required to consider how 16 and 17-year-olds would be treated. And the way it basically works is that if you're 16 and 17 years old, you can be held criminally responsible for felonies, but not misdemeanors. So a misdemeanor for a 16 and 17-year-old is going to be treated in family court. If it's a felony, it can be diverted to family court. Unless it's a violent felony like robbery or a homicide, in which case it has to be treated in adult court. There's a whole number of complex procedural rules that we don't need to get into, which is a good thing because it would take us a couple of weeks. How the new law moves the 16 and 17-year-olds through the judicial system. We don't need to master it, again, for our purposes. But the takeaway is, in New York State, the age of criminal responsibility has been raised to 18. However, people 13 to 17 under the right circumstances can still be treated as adult offenders in the adult criminal court. So we'll stop this part of the video and get into the criminal procedure material. Let me just change the screen. So now I now have the basics of criminal procedure in New York, and we begin with identifying three different types of, or three different categories of charges. In New York, these are known as accusatory instruments. We have an information that charges the defendant with a misdemeanor or a violation. We have a felony complaint. Hold on to your hats. It charges the defendant with a felony. And then an indictment. And if you remember the way cases work through the court system, if we're looking at a felony, it will be handled by the grand jury of a particular county. And that's going to charge a felony and possibly a misdemeanor if it goes along with a felony. Oftentimes you see burglary and is the felony, and petty larceny is the misdemeanor. In other words, someone broke into your house and stole a TV set. Okay, and so the information and felony complaints are, if you might remember this, in a different form, are filed in city, town, and village courts. When I say might remember it, this is what we were doing back in January. And indictments are filed either in the county court or New York State Supreme Court. It's a matter of administrative convenience from the perspective of the state. Now, a criminal action commences when the first accusatory instrument is filed with the court. But the question then arises, how is the defendant's initial court appearance obtained? And we need to know there whether the action was taken by law enforcement before the criminal action was commenced, meaning before there was a filing of the charges, or after the action is commenced. So examples of the first category would include the police observing a defendant allegedly committing a crime while driving erratically, and the police are going to pull the defendant over, and conceivably if there's evidence of alcohol ingestion or perhaps marijuana ingestion. I don't quite know how they're figuring that out, other than because they don't have a blood test worked out yet to put on the scene, or a breathalyzer for pot. I don't believe yet. In any event, so the defendant's arrested, but notice the charge hasn't been filed yet. Examples in the second category, meaning that no steps are taken to get the defendant until after charges would be filed, would be a person going to the police station reporting that they have been a crime victim, and they identify a person. So now we're in the second category. If we're in the first category, meaning the defendant's initial court appearance before an action is commenced, there's two steps that can be taken. One is an arrest, and the second is an appearance ticket. An arrest, you're always going to know when you're arrested, believe me. I'm thinking back, because you've been taken into custody. Your freedom of movement has been confined. An appearance ticket is a written notice signed and issued by law enforcement personnel directing the defendant to appear in a designated court at a designated future time. Now, in 2019, there was significant legislation in New York known as the Bail Reform Act. It does a lot of things. And under the Bail Reform Act, appearance tickets are mandatory for all misdemeanors and all e-felonies, except in a few instances that we don't have to concern ourselves with. So there are occasions now where a defendant is given an appearance ticket, and in 2016, by way of example, the defendant would have been arrested. The idea of the Bail Reform Act, or certainly one of its ideas, was to limit the circumstances under which a person would be held in custody before the charges against the person were resolved. Now, let's assume that a charge has been filed and no steps have been taken. So what steps will be taken? In other words, what are the steps taken to secure the defendant's initial court appearance after the criminal action is commenced? and there are two different ways to secure the defendant's initial court appearance, both of which are taken by a judge of the court in which the charges are filed. The judge can either issue a warrant of arrest, which is a direction to the police to find the defendant and arrest the defendant, or a summons. The summons is served by the police on the defendant, and it directs the defendant to appear in court at a certain place and time. A summons must be issued if the defendant is charged with a misdemeanor. If it's a felony, the judge has the ability to issue a warrant of arrest. Now we get into the next step. Is the defendant is in court for the first time, and the judge in front of whom the defendant appears now has to issue what is known as a securing order, and that has the purpose of ensuring that the defendant will be making the defendant's future court appearances. And there's three different types of securing orders. One is to commit the defendant to the custody of the sheriff. The second is to release the defendant on his or her own recognizance. And three, to set bail. I think you get a sense of committing the defendant to the custody of the sheriff is just that. Releasing defendant, we used to say OR. You get a sense of what that is, obviously, in setting bail. Now the defendant must meet the conditions of bail to avoid being in pretrial custody. And under the Bail Reform Act, again, it really was almost earth-shaking in the changes it brought about in this area. Not only earth-shaking, I might add, but also controversial. So I suspect that Bail Reform Act is going to be tweaked. It's pretty complex, and I'm just identifying a few important highlights. And under the Bail Reform Act, judges are required to release defendants with the least restrictive conditions, and in the process, they cannot use cash bail, partially secured bail, or secured bail. So for misdemeanors and nonviolent felonies, cash bail in any of its forms and pretrial detention are eliminated. So there's a lot more people who are not in custody. Violent felonies still permit the judge to commit the defendant to the custody of the sheriff or use the traditional forms of bail. So that gives us a sense of the Bail Reform Act. It's if you will, still developing. I'm going to stop the video here so I don't just unintentionally end it during the middle of a sentence, and I'll do the rest of the basic criminal procedure stuff in a next video.